3 lawyers stepped onto my porch at sunset and pushed a lawsuit packet toward my chest. The HOA had sent them to force me to remove my greenhouse, surrender a side yard easement, and pay fines on property I owned outright. Richard Collins stood at the curb behind them with his arms folded, watching like a man waiting for a door to close forever. The packet carried a county filing caption, a hearing threat, and a compliance deadline that could scare an ordinary homeowner into signing anything. I recognized the defect in the first page before the tallest lawyer finished speaking. My porch light clicked above us. Moths circled the glass. The paper smelled like fresh toner and warm ink. One lawyer read from a letter in a practiced voice. Another held a tablet against his chest. The third kept glancing past me into the hallway. Then the light hit the black robe hanging over my arm. His mouth stopped moving. I had just come home from court. My name is Michael Carter. I am 58 years old, and I had served on the county bench long enough to recognize intimidation dressed as procedure. I did not say that. Not yet. I only looked down at the packet, then back at the 3 men standing on my welcome mat. Behind them, Richard smiled too early. That was his first mistake. He thought silence meant fear. The tallest lawyer told me the HOA was prepared to pursue all remedies if I refused immediate compliance. His voice was smooth. Too smooth. He had said that line before. The folder was thick, but the pressure inside it was simple. Pay. Sign. Yield. Move. I took the documents without inviting them in. The evening air smelled like cut grass from the neighborhood lawns. A sprinkler ticked somewhere across the street. Richard shifted his weight near his black sedan. He wanted a scene. I gave him none. The lawyer asked if I understood the seriousness of the matter. I looked at the county seal printed near the top of the page. Then I looked at the deadline they had invented. I understand exactly what this is, I said. For the first time, nobody on my porch answered quickly. The youngest lawyer finally noticed the brass nameplate beside my door. Honorable Michael Carter. Retired senior judge. His eyes moved from the nameplate to the robe, then to the packet in my hand. His throat tightened. Richard did not see it from the curb. He was still smiling. I closed the door gently and stood in the quiet hallway while their footsteps retreated down the path. The house felt colder than before. I placed the packet on my dining room table and turned on the lamp. The first demand was bad. The second was worse. The third made me sit down. They were not just trying to find me. They were trying to create control over a strip of land my deed never gave them. Then I found the same paragraph repeated in 3 older letters. This was not their first doorstep. I spent the next 2 hours at my dining room table under the warm glow of a single lamp. The packet lay open beside a yellow legal pad. Outside, crickets chirped beyond the screened windows. The neighborhood had settled into its usual evening rhythm. Inside my house, something entirely different was unfolding. I read every page once. Then I read everything again. The language was polished. The threats were carefully worded. The pressure was obvious. A few pages in, I found the same paragraph repeated almost word for word across multiple notices. That caught my attention. It looked less like legal analysis and more like a template. I turned another page. Then another. A pattern began taking shape. The HOA was not simply targeting me. The documents referenced prior enforcement actions. Several property addresses appeared in attached exhibits. Most people would have skipped over them. I wrote every address down. A cold cup of coffee sat untouched beside me. The clock on the microwave read 9:42 p.m. The house remained quiet except for the occasional rustle of paper. Every few pages, another detail surfaced. Another demand. Another threat. Another reference to authority they claimed to possess. Then I noticed something else. The supporting exhibits did not always match the allegations. Some photographs appeared unrelated. Some descriptions seemed copied from other files. It was subtle. Easy to miss. But once I saw it, I could not stop seeing it. Around 10 o'clock, I opened my laptop. The blue Light filled the room. I searched public records connected to several addresses from the packet. One property belonged to a retired teacher. Another belonged to a widow who had lived in the neighborhood for decades. A third belonged to a young family. The same law firm appeared repeatedly. The same HOA board members appeared repeatedly. Richard's name appeared almost everywhere. That felt important. I opened additional records. The deeper I looked, the more familiar the structure became. Demand letter. Compliance notice. Escalation. Settlement pressure. The sequence repeated again and again. Midnight arrived quietly. Wind brushed against the trees outside. Shadows stretched across the room. I rubbed my eyes and reviewed my notes. One address stood out from the others. The owner had challenged the HOA several years earlier. The case never reached a hearing. It disappeared after a settlement agreement. That seemed unusual. I searched further. More records surfaced. The same attorney signed several of them. My legal pad was nearly full now. Arrows connected names. Addresses connected dates. The picture was becoming clearer. Then I reached the final section of the packet they delivered to my door. Attached behind the demand notice sat a document labeled Supporting Authority. I read the first page. Then the second. By the third page, I sat back in my chair. The neighborhood outside remained peaceful. Inside my house, the entire dispute had just become much larger. One signature near the bottom changed the direction of everything. The next morning could not come soon enough. I was already dressed when the sun came up. The packet sat exactly where I left it on the dining room table. Pale morning light spilled through the windows and stretched across the stack of documents. The signature that caught my attention the night before stayed in my mind. I poured a cup of coffee and opened my notebook. Steam drifted upward. The house was silent. I started with the address that had bothered me most. A retired teacher lived there. Public records showed years of ownership. Stable history. No major disputes. Yet the file attached to the HOA demand package described her as a repeat violator. That description did not fit the record. I kept digging. 10 minutes later, I found another address. Then another. The pattern tightened. Different homeowners. Different situations. The same pressure. The same legal language. The same sequence. Demand. Deadline. Escalation. Settlement. Something else stood out. Several cases ended abruptly. No hearing. No public resolution. Just silence. That kind of silence usually leaves a trail. I followed it. By mid-morning, my legal pad contained 2 full pages of notes. Names connected to dates. Dates connected to letters. Letters connected to attorneys. Richard Collins appeared again and again. Not always at the center, but always nearby. I leaned back in my chair and looked through the kitchen window. A delivery truck rolled down the street. A dog barked somewhere beyond the neighboring fence. Ordinary sounds. Ordinary morning. Yet the deeper I looked, the less ordinary this became. Around 11 o'clock, I made a phone call. An old colleague answered on the second ring. We exchanged a few pleasantries. Then I asked about one of the attorneys listed in the documents. There was a pause. Papers shuffled on the other end. The answer was careful. Professional. But it confirmed enough to keep me moving. After the call ended, I opened another folder. Inside were archived HOA meeting minutes available through public records. I scanned page after page. Most were routine. Landscaping approvals. Budget discussions. Maintenance reports. Then I found references to enforcement initiatives. The wording looked familiar. Too familiar. Several phrases matched language from the packet sitting on my table. My eyes moved back and forth between the 2 documents. The similarities were impossible to ignore. A chill settled over the room despite the warm sunlight outside. Somebody had been using the same playbook for years. Just after noon, another detail surfaced. One homeowner had pushed back. Hard. Unlike the others, he documented everything. letters, dates, meetings, correspondence. The file ended without explanation. That bothered me more than anything else. Cases do not simply vanish. Not without a reason. I opened one. Final document connected to that address. The page loaded slowly. When it finally appeared, I stared at the screen for several seconds. There it was again. The same signature. The same attorney. And this time, a name appeared beside it that changed the entire picture. I wrote it down immediately. Then I reached for the phone. I called the number before I could talk myself out of it. The line rang twice. Then a woman answered. Her voice sounded cautious at first. I introduced myself and mentioned the address connected to the old HOA dispute. Silence followed. Not long. Just enough. Then she asked how I found her. Afternoon sunlight spilled across my dining room floor while I listened. I explained that I was reviewing public records connected to several enforcement actions. Another pause. This one lasted longer. Finally, she laughed softly. Not because anything was funny. Because she had not heard anyone ask questions about that situation in years. We spoke for nearly 40 minutes. The story she told matched the patterns sitting in my notebook. Threatening letters. Escalating demands. Repeated references to legal consequences. Pressure to settle quickly. Pressure to stop asking questions. She described neighbors who simply gave up. Some paid fines. Some signed agreements. Most wanted the problem to disappear. I wrote as fast as I could. My pen scratched across the paper. Outside, a lawn mower hummed somewhere down the block. The neighborhood looked peaceful. The stories inside my notebook did not. Before ending the call, she mentioned another homeowner. A retired veteran who had challenged the HOA years earlier. She gave me his name. 20 minutes later, I was speaking with him. His memory remained sharp. He remembered dates. Meetings. Board members. Attorneys. He remembered Richard. Most importantly, he remembered the exact language used against him. Several phrases matched the packet delivered to my door almost word for word. That caught my attention immediately. The same language. The same tactics. Years apart. The veteran described how quickly pressure increased once he questioned their authority. Certified letters arrived. Additional notices followed. Meetings were scheduled. Then suddenly everything stopped. He never learned why. Neither did I. At least not yet. By late afternoon, my dining room table looked like an investigation room. Notes covered every available surface. Names connected to addresses. Addresses connected to timelines. Timelines connected to board decisions. The picture was becoming clearer. And uglier. Around 4 o'clock, I opened the archived meeting minutes again. This time I focused on attendance records. One name appeared repeatedly beside Richard's. The same attorney whose signature appeared throughout the files. Meeting after meeting. Year after year. That relationship seemed deeper than simple representation. I highlighted every appearance. Then I noticed something else. During several enforcement discussions, homeowner names were omitted from the public record while outcomes remained documented. That was unusual. My eyes moved back through the pages. The omissions occurred too consistently to ignore. The room felt warmer now. Sunlight reflected off the window glass. Dust floated through narrow beams of light above the table. I stood and stretched. Hours had disappeared. The deeper I looked, the larger this became. What started as a demand package aimed at my property was beginning to expose something much broader. Then my phone vibrated across the table. The caller identification displayed a name I recognized from the documents. I answered immediately. The first sentence changed the entire direction of the investigation. The voice on the phone belonged to a former HOA board member. He sounded nervous from the first word. Traffic noise hummed faintly in the background. He asked if anyone knew we were speaking. That question alone told me enough. I assured him the conversation was private. For a few seconds, all I heard was his breathing. Then he started talking. He served on the board nearly 6 years earlier. At first, he believed the enforcement actions were legitimate. Most board members did. They were told the HOA was protecting property values. They were told aggressive action prevented future problems. The explanation sounded reasonable. Until certain files began disappearing. I sat down immediately and opened a fresh page in my notebook. Sunlight had faded outside. The room glowed under a single lamp. The former board member described closed-door discussions that never appeared in official meeting minutes. He remembered homeowners being labeled difficult before any investigation occurred. He remembered settlement agreements being celebrated as victories. One detail stood out above everything else. Certain properties were targeted repeatedly regardless of compliance. That changed the entire context. This was not about resolving disputes. This looked like pressure. My pen moved quickly across the paper. He gave me dates, names, meeting locations. Every few minutes I stopped him and confirmed details. The more he spoke, the more pieces fell into place. Then he mentioned a file. A specific file. According to him, one homeowner challenged the HOA's authority with documentation so strong that several board members wanted the matter dropped immediately. Richard refused. The dispute continued anyway. That decision created tension inside the board itself. Several members resigned over the following year. I wrote down every name. Outside, darkness settled across the neighborhood. Porch lights flickered on. A car door slammed somewhere down the street. The ordinary sounds felt distant now. The former board member lowered his voice. He said one attorney attended meetings far more often than residents realized. Not just legal consultations. Strategy sessions. Enforcement planning. Internal discussions. That attorney's name matched the signature appearing throughout my documents. My notebook was filling faster than ever. Then the conversation took another turn. The former board member described an internal memorandum circulated years ago. He never received a copy. He only saw it briefly during a meeting. But he remembered its purpose. The memorandum identified properties considered vulnerable to legal pressure. I stopped writing for a moment. The room felt very still. If that memorandum existed, it changed everything. He could not prove it existed. Not anymore. But another person might. Before ending the call, he provided one final name. A woman who handled administrative records for several years. According to him, she kept copies of nearly everything. We ended the conversation shortly afterward. I placed the phone on the table and reviewed my notes. The stack of papers beside me looked taller than before. The dispute at my doorstep was no longer the center of the story. It had become the entry point. Somewhere inside years of records sat the explanation connecting every homeowner, every demand letter, and every unexplained settlement. Then an email notification appeared on my screen. The email arrived at 8:17 that evening. I opened it immediately. Attached were scanned documents from the former records administrator mentioned during the phone call. The files were old. Some pages showed coffee stains. Others carried handwritten notes in the margins. I downloaded everything and spread the documents across my dining room table. The soft hum of my refrigerator filled the quiet house. Rain tapped lightly against the kitchen window. The first folder contained meeting agendas. The second contained internal correspondence. The third stopped me cold. It held archived enforcement summaries dating back nearly a decade. I sat down and began reading. Page after page revealed the same pattern. Certain homeowners appeared repeatedly. The same attorney appeared repeatedly. Richard's name surfaced throughout the records. Sometimes directly. Sometimes indirectly. The consistency was impossible to ignore. I highlighted dates and marked references. Every few minutes another connection emerged. The deeper I went, the more organized the system appeared. This was not random decision-making. It looked structured. Deliberate. Carefully maintained. Around 9 o'clock, I found a memorandum. Not the one mentioned during the earlier call. Something closer to it. The document discussed enforcement priorities and resource allocation. Most of the language sounded routine. Then one section caught my attention. Properties were categorized according to anticipated resistance. I read the paragraph twice. Then a third time. The wording remained exactly the same. Homeowners were effectively being sorted according to how likely they were to challenge board actions. My pen froze above the page. Rain intensified outside. Water streaked down the glass. I kept reading. Several names from my notes appeared again. The retired teacher. The veteran. Other residents I had never met. Suddenly the earlier settlement agreements looked different. So did the abandoned disputes. A few pages later, I found email exchanges discussing legal expenses. The board worried about publicity. They worried about costs. They worried about challenges reaching public hearings. One message stood out. It recommended resolving disputes before homeowners obtained independent legal review. I leaned back slowly. The room felt smaller now. The pressure tactics described by former residents were no longer isolated stories. They were beginning to align with actual records. Shortly after 10 o'clock, my phone vibrated. The caller identification displayed Richard Collins. I let it ring once before answering. His tone sounded confident. Too confident. He asked whether I had reviewed the packet delivered earlier. I told him I had. A brief silence followed. Then he reminded me about the deadline. The conversation lasted less than 2 minutes. Yet something about it felt different. He sounded certain the matter would end quickly. That certainty suggested he still believed he controlled the situation. After the call ended, I returned to the documents. Near the bottom of one folder sat a file I had not opened yet. It carried a date from 7 years earlier. The homeowner's name meant nothing to me. At least not at first. Then I opened the attachment, and saw exactly why someone had saved it all these years. The file opened with a scanned letter dated 7 years earlier. The paper looked worn. The edges were slightly faded. A homeowner had written directly to the board after receiving enforcement notices almost identical to the ones delivered to my door. I read every line carefully. The complaints sounded familiar. Deadlines. Pressure. Threats of escalating action. Requests for documentation that never received complete answers. Then I reached the attachments. That was where things changed. The homeowner had preserved everything. Meeting summaries. Correspondence. Photographs. Certified mail receipts. Even handwritten notes from conversations. I moved closer to the screen. Rain continued tapping against the windows. The clock on the wall showed nearly 11 o'clock. One attachment contained a comparison chart. It listed statements made by the board beside statements made later by their attorney. Several did not match. Another attachment documented changes to enforcement claims over time. The differences were small individually. Together they painted a very different picture. I printed several pages and spread them across the table beside my notes. A pattern emerged almost immediately. The same sequence appeared again. Initial complaint. Escalation. Legal pressure. Settlement discussion. Abrupt conclusion. The names changed. The structure did not. That was important. Every few minutes I discovered another connection. Then I found something I had not expected. A letter from an insurance consultant advising caution regarding certain enforcement actions. The language was professional. Direct. Measured. The warning was clear. Continued disputes could create unnecessary exposure for the association. I read the letter twice. Apparently somebody had raised concerns years ago. Yet the enforcement efforts continued anyway. That detail stayed with me. Around midnight, I organized everything into timelines. My dining room table disappeared beneath stacks of paper. Yellow legal pads. Printed emails. Archived meeting minutes. Property records. The investigation had grown far beyond my original dispute. What began with 3 lawyers on my porch now connected to years of documented behavior. The realization settled heavily across the room. Then another detail surfaced. Several homeowners who challenged the board eventually disappeared from later records. Not physically. Administratively. Their disputes simply ended without meaningful explanation. Some accepted settlements. Some moved away. Others stopped appearing in available documentation altogether. The gaps bothered me. Gaps usually exist for a reason. I highlighted every one. Shortly after midnight, another email arrived from the former records administrator. This message contained only a few sentences. She apologized for not sending one additional file earlier. According to her, it was the document most people spent years trying to find. Attached beneath the message sat a single PDF. My pulse quickened slightly as I downloaded it. The file was small. Only a few pages. Yet the title alone explained why it mattered. It referenced internal enforcement classifications. The same phrase described during my earlier phone call. I opened the document carefully. The first page confirmed everything. Properties had been categorized according to anticipated resistance and projected legal costs. Several names from my investigation appeared on the list. So did mine. My name had been added only months earlier. Someone had planned this long before those lawyers reached my porch. The final page revealed who approved the system. The approval signature belonged to Richard Collins. I stared at the page for several seconds. Rain continued falling outside. Water slid down the dark glass in thin streams. The house was completely silent except for the ticking clock above the kitchen doorway. For days, pieces of the puzzle had been falling into place. Now I finally had a document connecting everything. I printed the file immediately. The printer hummed across the room. Warm paper slid into the tray. I placed the pages beside the original packet delivered to my porch and began comparing dates. Another connection appeared. Then another. Richard's approval signature matched the timeline perfectly. Enforcement campaigns increased after the classification system was implemented. The targeted properties matched names appearing throughout the archived records. The retired teacher was there. The veteran was there. Several homeowners from previous settlements were there. So was my address. A note beside my property contained language that caught my attention immediately. It described anticipated resistance. It referenced legal sophistication. It recommended accelerated escalation. I read the sentence twice. Whoever prepared the file expected a challenge before the first letter was ever delivered. That changed the entire narrative. Shortly after 1 o'clock in the morning, I called the former records administrator. She answered on the third ring. Her voice sounded tired. When I mentioned the document, she became very quiet. Then she confirmed it was authentic. She remembered seeing revised versions over the years. She remembered objections from certain board members. Most importantly, she remembered a meeting where concerns were raised about fairness and transparency. Those concerns were dismissed. I wrote down every detail she provided. The conversation lasted nearly half an hour. Before hanging up, she mentioned one final thing. According to her, a special board meeting was scheduled for later that week. Richard planned to discuss ongoing enforcement actions. My property was reportedly on the agenda. That information changed my plans immediately. After ending the call, I organized every document into chronological order. The dining room table disappeared beneath stacks of evidence. The timeline stretched back nearly a decade. Every major event now connected to another. Every missing piece had begun finding its place. Around 2 o'clock, I noticed an email buried inside the archived correspondence. It had been overlooked because the subject line appeared routine. The content was anything but routine. The message discussed public perception risks if enforcement criteria became widely known. I felt a chill despite the warm room. Someone inside the organization had understood the danger years earlier. Yet the system continued. I highlighted the passage and added it to my growing file. Dawn arrived faster than expected. Pale light crept through the windows. Birds began calling outside. I had not slept. I did not care. For the first time since the lawyers appeared at my door, I could see the entire structure. This was never about landscaping violations, compliance notices, or neighborhood standards. It was about leverage, control, pressure. The evidence no longer pointed in different directions. It pointed toward the same small group of decision makers. Then my phone vibrated with a new message. The board meeting agenda had just been released. The board meeting agenda appeared in my inbox just after sunrise. I opened it immediately. My property sat near the top of the enforcement section. So did several names I recognized from months and years of archived disputes. The pattern was no longer hidden. It was scheduled, organized, documented. I printed the agenda and added it to the growing stack on my dining room table. The papers formed a timeline stretching across nearly a decade. Every major decision now connected to another. Every letter connected to a meeting. Every meeting connected to the same small circle of people. By the time evening arrived, I was ready. The meeting room filled slowly. Residents took seats along the walls. Board members shuffled papers beneath bright overhead lights. The smell of coffee drifted through the room. Richard sat at the center of the table with the same confidence he carried on my front porch. He looked around the room as if nothing had changed. For a few minutes, routine business continued. Budget updates, landscaping reports, maintenance discussions. Then the enforcement agenda began. My property was mentioned. Richard started reading from prepared notes. I listened quietly. Several residents did the same. Then one homeowner raised a question. Another followed. The atmosphere shifted. Richard attempted to move forward. The questions kept coming. I stood when my turn arrived. The room grew noticeably quieter. I placed several documents on the presentation table. Not accusations. Not opinions. Documents. Meeting records. Archived correspondence. Enforcement classifications. Public records. Timeline summaries. The evidence spoke for itself. I explained how the same enforcement structure appeared repeatedly across multiple homeowners and multiple years. I explained how certain properties had been categorized according to anticipated resistance. Several people exchanged surprised looks. Others opened copies of documents distributed before the meeting. Richard tried to interrupt twice. The room no longer belonged to him. One board member examined a page and frowned. Another asked where the records originated. I answered calmly. Everything came from legitimate sources. Everything could be verified. The discussion continued for nearly an hour. Residents who had remained silent for years began speaking. Former disputes resurfaced. Old questions returned. Some board members appeared genuinely shocked. Others looked uncomfortable. The attorney whose name appeared throughout the records remained unusually quiet. That silence said more than any statement could. By the end of the meeting, motions were introduced. Reviews were requested. Independent examination of prior enforcement actions was proposed. Nothing dramatic happened. No shouting. No spectacle. Just a room full of people finally seeing the same picture at the same time. As the meeting adjourned, Richard gathered his papers without looking in my direction. The confidence I saw on my porch was gone. Outside, cool night air moved through the parking lot. Residents lingered in small groups discussing what they had learned. Several thanked me for bringing the records forward. Others simply nodded. The investigation that began with 3 lawyers at my door had uncovered something much larger than a property dispute. It revealed a system built on pressure, secrecy, and assumptions that nobody would ever compare the pieces. They assumed wrong. Justice did not arrive with noise. It arrived with patience, records, and truth. And that was enough.